After months of anticipation, the Supreme Court today has unanimously ruled that a representative action for breach of the Data Protection Act 1998 should not proceed. The claim was brought against Google by Richard Lloyd, who was seeking to act as a representative on behalf of over 4 million iPhone users. The basis of the claim was that a so-called Safari workaround implemented by Google had allegedly allowed it to place third-party cookies onto iPhones without an individual's knowledge or consent. The claim was brought on behalf of every affected individual, using a representative action mechanism in Rule 19.6 of the Civil Procedure Rules. Now, this allows a representative action to be brought if you can demonstrate that each affected individual shares the same interest in the claim, but historically that's been a difficult test to pass. For instance, individuals would not have the same interest in a claim where they suffer differing degrees of harm. Lloyd sought to disavow the differences in harm between the members of his class by instead seeking a uniform amount of damages per head, which he claimed all those had suffered in common. This was based on a principle that each affected individual had suffered the same loss of control of their personal data. The Supreme Court's decision today concerns whether Mr. Lloyd should be granted permission to serve his claim on Google outside of the jurisdiction, as Google is based in the USA. The High Court originally refused him permission, a decision which was then overturned by the Court of Appeal. Google then appealed that to the Supreme Court. And the Supreme Court's decision deals with two key issues. The first is whether those affected had suffered damage within the meaning of Section 13 of the Data Protection Act 1998. And the second is whether the members of the class have the same interest in the claim. Bryony, Hurst and I will now look at 4 key takeaways from the Supreme Court's decision.
As data privacy litigators, currently we see literally hundreds of claims across our desk every day where there is no actionable claim for financial harm or emotional harm. In fact, the only damages claim is for this in principle damages for loss of control of personal data. This can arise both in post-data breach claims, but also in relation to other allegations of data protection violations, for instance, claims arising out of cookie practices. The Supreme Court's judgment today makes very clear that a claim for loss of control damages alone simply cannot work under the wording of the Data Protection Act 1998. So for any claims arising out of events that occurred before the 25th of May 2018, they're basically a non-starter. The decision also casts pretty strong doubts over the ability to make these kind of claims for loss of control under the GDPR as well. So we expect to see less of these claims landing on our desks in the first place, and where they do, we've got far better arguments to push back on these claims hard from the get-go. Without loss of control damages, it's also going to become a lot harder for claimants to frame a group action using the CPR 19.6 representative action route because of that need to demonstrate that the same harm has been suffered. Claimants are far less likely to be able to show that all members of a class have indeed suffered the same harm when there are varying degrees of harm, both in financial terms and also emotional terms. So we would expect to see some drop-off in group actions in this area too.
One of the driving factors behind the increase in data protection claims has been the interest of litigation funders in this area. But the decision today should have a noticeable impact on how willing litigation funders are to back data protection claims. The Supreme Court have indicated that the issue of determining damage is unlikely to be suitable for claims using the representative action mechanism because it needs to be looked at on an individual by individual basis and also needs evidence of the extent to which each individual has been affected by an incident. And this is exactly what Mr. Lloyd was hoping to avoid because doing so incurs significant legal cost. The result of that is that the economics underlying these group actions becomes far less attractive to litigation funders, who will have to invest far more capital in order to achieve a result.
If loss of control is off the table, then the only damages now available are either for material damage, so for financial loss, or for distress. But woven throughout today's judgment is a requirement that in order to persuade a court that damages should even be considered, claimants have to be able to demonstrate that a threshold of seriousness has been met. In other words, as the judge put it, the contravention of data protection law has to be non-trivial. And whilst the court didn't see it as necessary to offer a view on whether the threshold had been met in the particular circumstances of the Lloyd case, the decision does contain some useful indications, at least, as to what will amount to non trivial. Key factors seem to include whether or not the violation was deliberate, how long it lasted, and did the defendant profit as a result of the violation. This is potentially really helpful for organisations facing claims where none of those boxes are ticked. And they could be able to use that to argue the case should even be heard given the lack of seriousness. For example, a claim arising out of a short-lived accidental change in a website's cookie settings, which is something we see a lot of at the moment, may now be ruled out on that basis.
The facts of this claim didn't involve a data breach, but there is further good news in the judgment for defendants to those claims. Cold water has been poured on the idea that misuse of private information and breaches of data protection legislation should share the same remedies. And this means that while damages for loss of control are, in principle, available in a claim for misuse of private information, to be successful, it will need to be established that the information affected is private. A lot of personal data, though, is not private. And the misuse of private information also needs to arise from a deliberate act and not simply a lack of care. And that continues a theme from recent decisions of the English courts, which really casts doubt over whether misuse of private information is an appropriate cause of action when a defendant has been the victim of a third-party cyber attack. Often in those cases, there's no deliberate act done by the entity involved. So this, combined with the court ruling out loss of control damages and data protection claims, significantly limits claimants' options of recovery following a data breach.
To sum up, today's decision is a pretty major body blow for claimant lawyers and litigation funders operating in the data privacy space. I would imagine they're going to need a very cold towel over their heads before they attempt to reformulate a workable and, more importantly, economically viable structure to bring data privacy group actions going forwards. We'd also expect this decision to put the brakes on the number of low-value data privacy claims that organisations are receiving going forwards. But for the precise extent to which this slows down the growth of data privacy litigation in the UK, all we can really say for the time being is please continue to watch this space.